Look, good afternoon, ladies and gentlemen. Welcome to our biannual hybrid seminar/webinar. A massive thank you to those who are attending in person on this boiling hot day. Good effort. For those of you who don't know me, my name is Susanna and I'm apparently your MC for today. So one thing we have in common is you don't know what I'll say next and neither do I. A little bit. There is some housekeeping that I need to go through, so just bear with me. I want to try and make this webinar seminar as interactive as possible, so after each presenter has finished talking about their segment, I want to invite as many questions as possible. I know we've got a few newbies around the place, so I know that some people are uncomfortable or a little bit shy to ask questions, but I would like to encourage you to do so. For those who are attending in person, I just want to tell the speakers today, if there are questions from our attendees attending the seminar in person, please repeat their question because chances are those attending by webinar won't be able to hear them. So that's the first thing. The second thing is, can I just get a couple of our attendees who are attending by webinar to either raise the virtual hand or perhaps chuck a comment in the chat box now, just to confirm that you can hear us all right? We're good? All right, and the only other thing that I want to, double check is, have we got I guess that's the only exit, so in case of any emergencies, please go through that door behind us all. Now to the lineup today, we've got Tracy Kerrigan speaking up first about some amendments to the Return to Work Act. Then we've got Neville John sharing the stage with Matilda Wise. They'll be talking to us about some recent changes to the Fair Work Act, which is a little bit different, but also very relevant to all businesses at hand. And then we've got a special guest speaker who's going to be discussing a very hot topic, but I won't tell you who that is just yet. I'll leave you hanging because I think that she or he deserves a proper introduction. So over to Tracy Kerrigan for now.
I'm definitely not the surprise guest, so you don't have to worry. What I am doing is answering some questions that have been tossed up as a result of some of the amendments that we've received in recent times. And I think there's a bit of a theme happening with these questions mainly being about things like Section 56 and 56A. So we're probably at that time in the Act where a lot of you are having to deal with paying a Section 56 payment and sometimes having to pay for a second or third claim, so having to deal with some of these issues. So the first question that we got asked was, if you have a worker who's not lost any time from work and basically they've got a medical expenses only claim, are they still entitled to a Section 56 payment? The very simple answer is yes, assuming their date of injury is post 1st July 2015. Any claim prior to that, obviously, there is no Section 56 entitlement. So they have to have a date of injury after 1st July 2015. But if they qualify, and you're probably mainly dealing with those claims now, there's no reference in Section 56 to weekly payments. It relates to a permanent impairment and a concept of loss of future earning capacity. Now, that is traditionally considered to be a capital payment and not substituting for actual lost income. And you can have a loss of earning capacity, which is an inability to sell your labour on the open labour market and still have that entitlement. And the full bench of the tribunal in the recent Jacurmis v Woolworths and Return to Work SA case basically said the same thing. That's what they described a Section 56 payment as being. And I'm going to talk a little bit further about Jacurmis in a minute in respect to another issue. But when I was doing these notes last night and then I looked at the Jacurmis case and I'd basically written that thing about what loss of future earning capacity meant, and then I looked at the judgment and went, oh, no, the judge agreed with me. So, you know, we're all on this, either that or I agreed with him without knowing. So, so basically it's not based on loss of income. It's based on permanent impairment, and if they meet the threshold and the date of injury falls after 1st July 2015. And as a further comment to that, the same would seem to apply to seriously injured workers who now have the ability to make a Section 56A election and request a lump sum payment under Section 56 as opposed to weekly payments. Now, I suspect those amendments were done by the government on the assumption that all seriously injured workers are off work and in receipt of payments, and as self-insured employers well and truly know, that is often not the case. And in fact, I recently had to give some advice about this very issue to a client who's got a very young worker, very serious injury, but still at work, and apart from their initial recovery phase, has always been at work and is now looking at getting, you know, a payment of some $400,000 and a full-time job that he's capable of undertaking. And we got advice from council because they were like, well, you know, he's not really received any weekly pay other than a short period when he was immediately in hospital. And the advice from council, and it was the same council who was involved in the Jacurmis matter, was that the amendments in Section 56A, although there's a reference to future entitlement to weekly payments, it isn't predicated on having a current entitlement to weekly payments. So council's advice in that matter was that there was really no point in arguing it because they did not consider that the argument would be in any way successful. Having said that, when you sort of think about it, if that person makes that election and takes that payment at that point in time, I guess if they eventually have to go off work because for some reason to do with their work injury they can't cope, then they would not have that entitlement to future weekly payments that they would otherwise have as a seriously injured worker, and they wouldn't also not have the entitlement to recovery and return to work assistance, which is also extinguished if they make the election. And we know also that the Act says once they make the election, they can't withdraw it, so they can't have second thoughts if they decide that's not the right thing for them. So it does seem to be that's a pretty simple answer, although there's no judicial authority. But I think if you look at Jacurmis, I think it also seems to suggest something along the same lines. So the next query was, can a worker who's assessed at greater than 35% get a Section 56 payment irrespective of their injury date? My answer to that is no, because under the transitional provisions, a worker who is seriously injured and injured prior to the 1st of July 2015 can't make an election under Section 56A, and I forgot to write down what clause that was, but it's in the transitional provisions, and I had a look at it last night. So these new Section 56A provisions, unless... Oh, no, Mark's going to say something. You can disagree with me or just give me... Sorry? Clause 4, thank you. I thought he was going to disagree with me and I was going to go, oh no, I checked something else with him, but I didn't check that. Clause 4, apparently. So, it has to be a post 1st July 2015 injury. And of course, there are some seriously injured workers who predate that date. So the next question, and this is also one that is an interesting one, is how does Section 56.6 work? Now, Section 56.6 is the provision that says, so a worker has one injury and gets a lump sum for economic loss under Section 56. If they have an aggravation of that injury, or it says a new work injury, then, and they have a further assessment, then there is a deduction in the second payment from the first payment. So I have had a case where a worker in very quick succession had 3 injuries for which, and they were post 1st July 2015, for which he had an entitlement. By the time he got to the third one, he had no entitlement on our interpretation of the Act under Section 56.6 because the monetary deductions ended up, the third injury, he got nothing. Now, the question is there any situation where rather than it being a monetary deduction, you would do a percentage deduction under the impairment assessment guides? I think to a large extent this question is going to be answered by the Court of Appeal in Jacurmis. The Jacurmis case has been argued and judgment is being awaited. The full bench of the tribunal took the view that, so the worker had had an injury in 2016 for which they were entitled to a Section 56 payment, and then an unrelated injury in 2017 for which again they had a further percentage assessment, but based on a monetary deduction, they got nothing for the second injury under Section 56 because there was a monetary deduction. And the interpretation that Return to Work SA, it was Woolworths was the employer, but Return to Work SA intervened in that matter. The interpretation that the compensating authority took was it's a monetary deduction, it doesn't matter that it's a separate and different and unrelated injury. That got up at first instance, but on appeal the full bench said no, that there had to be, and the quote was, in respect to a new work injury is a further work injury that gives rise to an entitlement to a lump sum and where a portion of the impairment is due to a previous work injury. So they were saying there had to be a connection between the two in order to do the monetary deduction. Now, of course, all of that could change depending upon what the Court of Appeal says, but for the moment, the law seems to be if you have subsequent and different injuries, that there is no monetary deduction. Now, whether or not there may be some factual circumstances where under the impairment assessment guides, there might be a percentage reduction by the assessor, but that would have to fall within those guides. So there'd have to be a prior impairment, again, some sort of relationship to get a percentage deduction under the impairment assessment guides. But the interpretation at the moment that a new and different work injury still attracts the monetary deduction is not the law until we know what the full court says. If you're in the situation where you might have that occurring in your business with a particular worker, it may be a situation where you have to really try and hold off what you're doing until such time as you know what the outcome of the Court of Appeal decision is. And like I said, the barrister I got that advice from told me that the matter was argued before Christmas, so I would imagine in the next few weeks, hopefully we'll get a decision and some of this might be a little bit more advanced. I mean, where you get a situation of a subsequent injury that's an aggravation, under the impairment assessment guides, technically the assessor might be able to do a percentage deduction for the prior impairment sustained. How that will then be interpreted in terms of how that works within Section 56(6) is anyone's guess. And that was actually the situation in the Onedy case, which is specific to hearing loss, but where the worker had prior compensation for hearing loss, put in another claim, had another loss. The assessor deducted the prior impairment and he fell below the 5% threshold. And when it went up to the full court, they said, no, you don't do that for hearing loss. It's just a monetary deduction. So, but that was really specific to hearing loss. So again, lots of questions, not necessarily all the answers. So our next query is, we've got a worker who has multiple unrelated injuries before and after 1st July 2015. If they are a seriously injured worker for the pre-2015 injury and possibly in receipt of make-up pay, and not seriously injured for their post-2015 injury, could they get a redemption for the former and a Section 56 payment for the latter? Yes, I don't think there's any restriction in terms of their ability to do that because, as I said, the Section 56 payment is not a payment for income. It's a payment based on whole person impairment and loss of function, and it's a capital payment representing future loss of earning capacity. If they're in receipt of make-up pay for their pre-2015 injury and they're seriously injured, so they're going to have an entitlement potentially to retirement age, which is 67, then you could redeem that entitlement. And obviously redeem medicals as well, so because there's now no restriction for redeeming medicals for seriously injured workers. So you can see that there are situations where people do very much seem to get significant duplicate entitlements because of the different concepts that are applying now. So yeah, that is the possibility. Can you resist a Section 56A election, especially if the worker is still at work? probably based on my other comments, I think you all know the answer is not that I know of, no. Of course, a worker who's at 50% or more has to go to the tribunal for approval, and we've had 3 cases about approvals by the tribunal of workers who are in excess of 50%. The first 2 by Judge Crawley were really rubber stamping, didn't really, just said in his view it was in the worker's best interest. There was obviously some medical evidence. The compensating authority took no part in either of those cases, so they didn't in any way take a view that as to whether or not the election should occur or be approved. The third one is a very detailed judgment by Judge Rossi. Those of you who know Judge Rossi are probably not surprised by that. He does like to write a good judgment and a long one. And he went through a lot of criteria of what he considered was necessary for a worker to satisfy him that approving the election was in his best interest. So what they thought was probably going to be a rubber stamp process, according to Judge Rossi, is not. But in terms of your ability to resist the election, I don't think there is. I think ultimately, unless, in your 35 to 49% category, once they make the election, I think you're just going to have to work out what the entitlement is. 50% or above obviously has to go to the tribunal, and ultimately it'll be up to the tribunal to make that decision. Is there any situation where you still need to use the Impairment Assessment Guide 2nd edition? Hopefully I'm not treading on our surprise guest's toes in this regard, but yes, there is. Very limited. If you have a claim made between 24th August 2021 and 22nd August 2022, which is when the Return to Work Sustainability Amendment Act came in, and the worker has made a request for a PIA assessment, then you are to use the 2nd edition guides, but otherwise at the moment you revert back to the 1st edition. Return to Work SA are looking at the guides, and I expect there will be some further amendments, but at the moment that's the one that you use. Just as a rule of thumb, possibly the ones that you're most likely to find in that category are hearing loss claims, because people make the claim and that's generally their date of injury. There might be, and they're making the assessment request virtually immediately. So they're an obvious one that might fall in that 1 year period. But now we're past 22nd August 2022, any hearing loss claims or other claims received after that date would fall back to the IAGs, the 1st edition. And there's only, if you look at the hearing loss claims, for those of you who are interested, there's only one real difference in the guides when it comes to assessment of hearing, and it seems to have tried to tighten up the discretion of the assessor to look at and to measure and include losses at frequencies below 2000 hertz. So it tried to make it a tighter scheme so that the Dr. C and Dr. F, I'll call them, who tend to regularly include those losses as part of their PIA assessment, had less discretion to do so. So very limited application, but there still is some application. And obviously, the further past we get to that, past those dates, the less likely you're going to even have to worry about it. And even, if you've had a date of injury in that period, but no request for an assessment's made, you don't have to worry about it at all. It's really only, I think, probably those hearing loss claims that are most likely to fall into that category, because they put their claim in and they make their request straight away, whereas most other injuries, they have the injury, then they've got to stabilise. That's all going to take time. By the time they've actually made a request to be assessed, you're probably past the date. But just be mindful if you do, there's clients who do get a lot of hearing loss claims, so that you might be in that category. This is one that's come in about income support under Section 40, so supplementary income support. Can you get more than one lot of supplementary income support? If you look at the provisions of Section 40, which says you get a maximum of 13 weeks. Now, those provisions were amended but only in respect to the issue of when surgery is approved. So like they deleted the reference to an application for approval of surgery under section 3321B2. Now it simply refers to surgery approved, but which takes place after the end of the second entitlement period. I've experienced a couple of cases recently where people have had more than one surgery now, post the end of their second entitlement period, and they've had more than 13 weeks, or they've had 13 weeks, and then they're coming back saying, right, now I've had my knee replacement, I've had my 3 arthroscopies back here, and I've had my surgery, but now I'm having my knee replacement, I want another 13 weeks. It's an interesting point. I'm arguing it at the moment. I can't promise you that it will go to hearing, because again, we're getting advice from council. And when you're only arguing actually about 13 weeks, the cost of arguing about 13 weeks probably outweighs the value of the 13 weeks. But it is an interesting point. And, you know, when I first spoke to council about it, he was like, oh yeah, I can see your point. And then he was like, oh, I don't know if you're right though. I was like, I know, that's why I'm asking you. But if you have that situation, I wouldn't automatically assume that you are liable for another lot of 13 weeks. I can tell you from discussions with the Return to Work SAs that they are not taking that point. So if people are having multiple surgeries at different times, they're just getting another lot of 13 weeks. But it's something to consider in terms of that section. Now, a flow-on question from that is, how many surgeries can you have when you're making that application? So a worker makes an application prior to the end of the entitlement period that I'm going to need surgery at some stage in the future. And as my example, I've got one where a worker said, I need a 2-stage surgery. This is what my doctor says. And I need this first, and then 6 weeks after that, I'm having this. So the client approved, said, yep, you've got your 2-stage surgery that apparently was recommended, and both on different dates, has now passed their 13 weeks, went back to work for a while, things haven't gone well, and now the doctor says, oh yeah, no, I need to redo the surgery. And I'm like, well, leaving aside the fact of this is the 4th knee surgery you've done on a very young woman and none of it's worked, so why would you be wanting to do it again? Does the approval encompass another lot of surgery? Again, I don't know the answer to that. I am arguing it though, because I think, there is an argument that you can't have unlimited surgeries. So unfortunately, I'm raising a lot of issues. I'm not necessarily giving you many answers to any of this, but I think these are some of the issues that are now coming to the fore, because we've kind of done a lot of the other stuff, so it's now really people who have sought their approvals and now they're actually having the surgery, but not necessarily having surgery that's working. Or they're coming to you with a total knee replacement. They've had 2 or 3 arthroscopies and now they're having their TKR, for which there is no limit in terms of when they can have it, because it's a therapeutic appliance. So are they entitled, for example, to income support under section 40? So yeah, a few issues, not a lot of answers, but some of these matters may get there, because some of these are important points, but Return to Work SA are not necessarily pursuing all of them. So that's it from me, unless anyone's got anything they want to ask or anything's come in. Where's Susanna gone? She's at the back.
I have just put a question up on the chat box, a question for our online attendees, but also for those attending in person at the moment. Have you actually experienced any situations where workers have requested multiple Section 40 payments? Anyone? No?
Yeah, I've definitely got cases, or at least one case.
Yeah.
I've got 2 actually. Mark,
raised his hand. Give me a second.
So yeah, that's an interesting one, because I've got 3 different scenarios. One's now in the past, 2 are current. One is a surgeon who said, I propose to do surgery A, but if that doesn't work, I'm going to turn around and do surgery B. The next one was surgery A failed. I've now got to go back in and fix what I didn't do right. The recovery wasn't as expected
wasn't
as it might have
optimum.
otherwise been.
I did everything right, but the recovery was not optimum. That's the one
Yeah.
I've got that one.
And the third was a scenario where there needed to be effectively some form of preparation surgery because the person had had previous issues with infection. So the surgeon said, I'm doing, this is his words, a 2-stage surgery. So effectively
yeah.
I'm doing something globally, but it's going to take 2 goes at it. And they both, in my particular case, occurred within the 13 weeks, and we're in effect in dispute about that matter now. Again, it's a question of what it's worth to, argue the toss for 13 weeks worth of payments, and if Return to Work SA are not looking at funding any, which they occasionally do when a self-insurer runs a matter, they might fund the council fees to get a point decided. Doesn't sound like they're going to be, well, certainly not on the 13-week side of things, but whether on the question of what is surgery in terms of, discrete events in a time continuum, whether they'd be interested in that issue, I don't know. But my guess is probably not, if that's their attitude about Section 40 in the first place.
Well, that's certainly a couple of people at Return to Work say that I asked about the issue, like in terms of trying to find out are they running any cases on it? Has this happened? Are they, because often they do run cases just to find out what the legislation means, but they looked at me like, oh no, we're not interested in that. I was like, oh damn, I thought it was a really good argument. I want you to take it on, but no, they're like, oh well, if your client takes it on, that's fine. So yeah, I've got virtually the same case, which is the 2-stage surgery. I've got to do this first, and then I've got to go back in and do this, and obviously that'll fix everything. It hasn't, and so now we're in I've got to go back in and do a revision. I'm like, well, this would be now the 4th revision of the same problem, and her knee continues to dislocate. So I'm just waiting for the request for the total knee replacement. But I suspect she's actually quite young, so I don't think we'll get that just yet, but you never know. So.
It's kind of coming through me rather than anyone attending in person or online. With regards to the election under Section 56A, say a worker makes the election, gets redemption advice, and then decides, don't like this, then changes their mind later on.
They've got to actually get my understanding is they have to get their advice in order to make the election. Because if you look at the form that Return to Work SA distributed, it's got professional, financial stuff that has to be signed off. So my understanding is they've got to get the advice first and then make the election. And then the Act does say that once you make the election, it can't be withdrawn. So if they suffer buyer's remorse, if we can call it that, it will be too late. Once they actually, my understanding is once they file the form, but they've got to get their advices first. So I'm assuming that's on the basis that they've got to be fully informed as to, what they're giving up, potentially, to what they might gain.
No, I think we can move on to our next set of
Thanks,
presenters.
everyone.
So thank you, Tracy. We've got Neville John up first, sharing the stage with Matilda Wise.
Oh, we're going to share. Oh. You can sit down for a while. Okay, thank you. You can move on to the next slide. I can't read it down there. It's way too small. Look, I'm just going to give you a quick, very quick overview of some of the amendments to the Fair Work Act. Those of you that practice solely in workers' comp probably it won't be of 100% interest to you, but there are some crossovers that could raise some interesting legal issues down the track. Sorry, how do I move the slides? Where's the ticker? That's why I can't move. That's better. Now I can read it. So, the first one I want to talk about is a change to the flexible working arrangements. Now, at the moment, there already are provisions under the Fair Work Act that deal with this, but the most important change as at June of this year will be a right for a worker that has their request rejected by the employer to actually take that to the Fair Work Commission through a direct avenue specifically designed for flexible working arrangement disputes, other than potentially at the moment a rather complicated way of potentially arguing that it's discrimination or some sort of adverse action being taken by the employer, or even extreme cases where if the request isn't granted, there could be an allegation of some sort of dismissal. So this only applies to particular persons, and the employees have to have been employed for a minimum of 1 year if they're permanent to even make the application, and if they're a casual, again a minimum of 1 year, but they have to be a regular and established casual, with also a reasonable expectation of continuing regular and systematic employment. So a fairly stringent test, similar to unfair dismissal rules regarding casuals. Now, you can see there the category of people that are able to apply for flexible work. Many of those repeated from the previous version of the Act, and a few inclusions. One that I'm rather offended by is just being over age 55. You seem to be some sort of disability or something, I don't know. But I think that's more of a transition to requirement type provision. What can you do as an employer if an employee does come to you and request a change in perhaps work hours, work location, work arrangements, days of work, etc. What you have to do as an employer, and this may well cross over into perhaps a worker that's on comp or on modified duties, to assess your reasonable business grounds, you have to take into account things like the expense. Is this something that you could feasibly afford? Would a change of arrangements impact on other employees and on their regular work patterns? Would it be impractical, to actually change the arrangements of other workers or recruit new ones to accommodate a particular worker? Would it result in a significant loss of productivity or efficiency? Would it have a negative impact on customer services? And also importantly, the nature of your business and the size of your business or organisation would be paramount. So clearly, a smaller employer would have a much stronger case than a larger employer in relation to being able to rearrange some of its workplace activities if or when required. So what will occur is if the employer says, yeah, look, yes, we can do it, all good, no problem. If the employer says, no, look, we really can't accommodate you, and the worker is not happy with that, they will now have the chance or the opportunity to consider the employer's rejection, which has to be in writing and has to be made within 21 days of the actual request. Once the worker's got that, they can then try and resolve that dispute with the employer, and if that doesn't achieve an agreed result, then they can apply to the Fair Work Commission for a determination as to whether the refusal is reasonable or not. And then what will normally happen is we'll probably follow the same process as we do in the Commission now and in the Tribunal, and that is it would go to a conciliation or a mediation initially, and ultimately, if that didn't resolve the dispute, it would go to arbitration. And then any orders of arbitration will be binding on the employer or the employee, depending on which way it goes. Possible orders, the request could be confirmed, the request could be refused, or the Commission would have the discretion to actually apply its own terms and conditions to accommodate the request. So it's something that may not have been contemplated by either party. The Commission can come up with its own ideas as well and impose those. So how does that impact on, and if there's a contravention of the order, obviously it has to be an arbitrated order. Then the pecuniary penalties under the Fair Work Act would apply with a maximum of $82,500 per offence for an employer, or lower for individuals. So working within workers' comp spheres, there is probably a dichotomy there between perhaps a worker that's on modified duties already, or modified hours, requesting some further flexibility, such as I want to work from home or change my hours to accommodate school obligations or some sort of carers obligations or whatever. Which Act prevails? Would it be the Fair Work Act? Would it be the Return to Work Act? Fair Work Act doesn't actually cover workers' compensation, so under the Constitution, the Return to Work Act should prevail because the Fair Work Act doesn't actually cover the field in this regard. But even so, there would be that interrelationship between the two, and you would probably still be required to assess on reasonable business grounds, but part of those grounds would be also how would that impact on the workers' rehabilitation and the opportunity to actually provide that to them. And clearly, you know, if they're needed at work and they can't perform their work at home, or they need to be supervised, etc., then you would have very good grounds, in my view, to reject such an application when taking into consideration the holistic view of the workers' employment and the circumstances of them being on compensation. I don't think Section 18 would be an issue because Section 65A of the Fair Work Act only really applies if you're in employment. So presumably, so obviously if a worker's in employment and they make an application, that's fine, but if they're outside of employment and they reapply under Section 18, then I think we're just dealing with Section 18 only and not the flexible work provisions. Until, or unless they actually get back under Section 18 and then they make the request. The next issue, new issue I should say, is there is now a prohibition of sexual harassment in the workplace. I'm sure that's all news to you. I'm not sure why we had to legislate because it's already been pretty much the law for a long time, but according to the Fair Work Act, as at 6th of March, so not very far away, sexual harassment will now be expressly prohibited. Now this prohibition applies obviously to existing employees, but also to prospective employees. So casting couch auditions are now out. And also applies to contractors, trainees, even work experience. So basically anybody in your workplace. And as an employer, you will be vicariously liable for the actions of your employees. So all the more important to ensure that you have in place procedures and policies and have ensured that your workers are aware of those and have acknowledged receipt of those in the event that something untoward does happen, and it does, we know, especially at Christmas parties, that you are in a position to be able to protect and defend a claim of vicarious liability by showing essentially that the worker has just breached all policies and procedures and has effectively acted in a serious and willful manner. The obligation will be on the employer to show that it has all reasonable steps in place to avoid the contravention. So it boils back to common sense, and if you haven't got existing policies in place, I'd be surprised. If you have, it might be worth a refresher just to review them and make sure that all employees, current and future, are aware of those. Again, similar process to the flexible work application. If an employee considers they have been sexually harassed, there's obvious avenues under workers' comp to bring a stress claim, or if there's physical injury as well, but beyond that they can apply to the Fair Work Commission for a stop order, which is quite self-explanatory. and they've actually got 2 years to seek that, which I thought was a odd sort of time frame, because I would expect if someone's been harassed for 2 years, by that stage, you know, they probably would have made a complaint. So I'm not sure why there's such a long period of complaint, but that's what the law says, or will say, as at March. It's not a compensation scheme, so the Fair Work Act or the Fair Work Commission will only be able to issue orders. Again, it will go to a conciliation mediation type setup to start with, and then arbitration if needed. And again, contravention would be a pecuniary penalty. So we'll have to wait and see whether that's utilised, given that quite often those types of claims either end up in a workers' compensation arena or a sexual discrimination claim or adverse action. And finally, I just want to touch on the extension of unpaid parental leave. Again, on the 6th of June, this will come into play. At present, an employee has the option to take parental leave and then request a further 12 months, excuse me, at the or just prior to the expiry of the first period of that leave, and that could be rejected by the employer, and that'll be the end of it. There is now going to be, well, basically what they've done is they've just added the dispute process that I've already discussed in the previous 2 slides, and that is an option to then take that straight to the Fair Work Commission and let the Commission decide whether the extension is warranted or not. And again, the employer will have to show reasonable business reasons for denying such a request, and we'll come back to essentially what I described in the first flexible slide regarding, you know, the cost, change of arrangements. Is it fair to or reasonable to have to provide a replacement for this person for another year? Nature and size of employer, etc. So, and also the length of the extension will be determined also by the time that the person requesting the extension, their partner, if they have one, whether they've also taken some unpaid leave during the same period. So if they have, that'll be basically taken off the equation. It's very difficult to talk about this topic without mentioning men or women, so it's just people that have babies. That's really about all I want to talk about. We do have a question, yeah?
Before we move on to Matilda, I do want to invite a couple of questions, and I myself have a question just in case people are a little bit shy to pose some questions.
Has this got something to do with your state of...
Actually, no. No, it is to do with the sexual harassment policies. How extensive do the written policies prohibiting sexual harassment need to be?
Sorry, how what?
How extensive
Oh.
do those policies need to be?
How long's a piece of string? It will depend, I guess, very much on the size of your workforce. You've seen our policy, which I drafted in one paragraph, but I wouldn't recommend...
That was basically it.
I can't, what's it say? It says...
You're all adults, don't do it.
Yeah, you know the line, don't cross it, that's it, pretty much. Common sense stuff, but obviously for a, you know, I don't expect we're going to be having to face claims, hopefully, but if we did, maybe our policy is a little bit brief. But no, it doesn't have to be highly comprehensive. It's most of it's common sense, and it's just really just explaining what is sexual harassment, what could be offensive to certain people. Don't do it, and if you do it, how to deal with a complaint, and have perhaps some sort of dispute resolution internal process before it goes anywhere else. Yeah.
All right. Any other questions for Neville before we move on to our next speaker? No?
Nope, good.
Thank you, Neville.
Hi everyone. If you haven't met me yet, my name's Tilly and I'm a solicitor at KJK with these guys. I have a keen interest in all things employment, so that includes human resources, workers' comp, work health safety, and industrial relations. So, just getting the slides. Sorry, technical difficulties. All right. First, I'm going to talk about the limitations on the new fixed contracts, which will be coming in from 6 December 2023. The new Fair Work amendments will now make it an offence for an employer to enter into a fixed contract with an employee that meets the following criteria. It spans longer than 2 years. It allows the contract to be extended or renewed for a period that extends the 2 years. It provides for an option or right to extend or renew the contract more than once. The contracts continue the same or they are substantially similar to or have similar employment relationships and work duties the same as the previous fixed contract, and the contract exceeds the 2 years and contains a right of renewal or the employee has been engaged under 2 consecutive fixed term contracts. So basically that just means that if the work duties completed in the next contract that expands 2 years, then that means that that will then be an offence for the employer to engage in that. However, you will be pleased to know there are a couple of exceptions that come under that, and if you apply, then this will allow you to have the 2 fixed term contracts that can extend longer than 2 years. Some of these are the employee is engaged to perform duties that are distinct and indefinable tasks that require specialised skills. The employee is engaged under a training contract. This could be an apprentice. An employee is completing work under emergency circumstances or during a temporary absence of other employees. So that's actually a really interesting inclusion. And employees is engaged to undertake essential work during peak demand periods, such as during COVID. So that creates an exceptions under that. And there are a lot of other exceptions that you could look into. This requirement won't come in until the 7th of December, which gives employers time to make arrangements for compliance. What does this fundamentally mean? If an employer enters into a fixed term contract with an employee that does not fall under the exception criteria, and the expiry mechanisms will be considered invalid, and all other terms in the contract will remain valid, effectively making it an ongoing contract. So it will just transition into an ongoing contract, and then that you then deal with it from there. The onus will now be on the employer to prove that the fixed term contract is not in breach of the Act and therefore falls under one of the exceptions. So that is now onus on the employer, bigger job. If the fixed term contracts are part of the business model, your business model going like it has been in the past, we would recommend assessing whether your contracts fall under the exceptions, and if not, making the appropriate arrangements as soon as possible to transition these employees to ongoing contracts. The next thing I'm going to talk about is the prohibition of pay secrecy clauses. The amendments to the Fair Work Act in banning secrecy clauses is quite an interesting one. That are common inclusion in employment contracts. Previously, pay clauses have notoriously given employers bargaining power when it comes to salary and employment condition negotiations, as employees don't have the ability to make comparison against their other peers. It also makes it harder for employees to band together to try and argue for better working conditions or higher pay because they're in breach of their contract in doing so or in discussing it. Starting on the 7th of December, all newly created employment contracts must not include a pay secrecy clause. For those employees with existing contracts that are stipulating a pay clause, this must be changed to reflect the new law as soon as possible. However, the existing pay secrecy clause will continue to operate until the contract is actually changed. So it will still be against your contract to speak out and discuss with your peers about your pay and your conditions until your employment contract is changed. However, from 7 June 2023 onwards, whether it's been removed or not, it will completely be invalid. What does this fundamentally mean for employers? Employers can now share information about their remuneration, including their pay, their conditions, their employment terms with others in their workplace and on the outside. They can also ask others about it. Employers cannot take adverse action against an existing or future employee for exercising their right to discuss remuneration. So this means if somebody who's applying for a job is asking other employees, what do you get paid? What does this role look like? What are these conditions? They cannot be penalised in any way for that. The Fair Work Ombudsman now has the power to commence proceedings for alleged complaints of adverse action in terms of an employer taking adverse action against an employee or a potential employee for discussing these things. Yep. Now I'm going to talk about the change to job adverts. Have you ever been on Seek and LinkedIn and looked at it and thought, are they actually able to pay this person this much? Oh, I've lost it. I certainly have. And as of the 7th of January this year, job adverts cannot display pay rates that would breach the Fair Work Act or any Fair Work instruments, including awards or enterprise agreements. This also goes for advertisements for positions with periodic pay. So when you're being paid an hourly rate, you now need to specify the hourly rate or tell the potential employee that there will be an hourly rate applying. All of these requirements will apply from 7 January regardless of this year, regardless of when the ad was posted. So if it was posted last year, it's now a requirement. And finally, just a little bit about paid family and domestic violence leave. A study conducted by the Australian Government's Office of Status of Women found family and domestic violence cost Australian employers $175 million annually in direct and indirect costs. To help lower these costs and support vulnerable members of our community, the Fair Work Act now allows for employees, including part-time and casual employees, to be given who previously had 5 days of unpaid family and domestic leave to now have 10 days of paid family and domestic leave. For the purpose of the Act, the family and domestic leave is defined as violent, threatening or abusive behaviour by certain individuals known to the employee that seeks to coerce, control the employee or cause them harm or fear. Starting from 1 February 2023, so it's already started, the new Fair Work amendments allow for employees, including part-time and casual employees, to have those in a non-small business to have the 10 days of paid family and domestic leave for any 12-month period. So that's already in effect. And for small business, that will come in effect from the 1st of August. But they can continue to use their unpaid family and domestic leave until that given date, till the 1st of August. So what does this mean for employers? Employers will need to revisit their workplace policies to ensure that they're supportive of employees experience family and domestic violence and allow for access for this form of leave, and also need to ensure that their process with respect to disclosure and record keeping is as confidential as possible to protect those in this vulnerable situation, and they've adequately budgeted to include the leave and pay the leave if necessary. For any more information or advice about the new Fair Work changes, please feel free to yell out to Neville or I, or give us a quick call, or send us an email. We're always happy to chat. Don't be shy. Is there any questions?
We actually A question come through on our chat, but it's directed to me only, so not everybody will have seen it. It's from Christy, which is really, really interesting. It says, on the issue of someone asking you for earnings and wage details, does the responder have to legally reply?
No. So you actually don't have to reply, that you have your own autonomy over that. You, obviously, they're allowed to ask. There's nothing that says they can't ask, but no, you don't have to reply. You don't have to share.
Any other questions from those attending in person? Just 1 second. We've got a question from Tony.
Yeah, just for this new family and domestic violence leave, so it's paid leaves from 1st of August, right? For sick leave, we have doctor certificate. For this kind of leave, any kind of evidence employee needed to provide to employer?
Yes. So the evidence that will obviously have to be between the employer and the employee, very confidential, but they, a doctor's certificate would suffice, a written letter from a psychologist. It actually is really up to your own discretion whether, obviously there needs to be some evidence provided, but just common sense in terms of does this suffice? Have you noticed previously that there's been some disturbance in the workplace because of this family domestic violence, etc.? There aren't actually any requirements in terms of evidence. It's just a matter of, the common sense and there is something you've got on record to support that leave. Yeah.
If a doctor give a certificate and the employee says that's due to this family domestic violence, but doctor certificate didn't specify this one.
As they often don't. They often just say a medical condition, you know, when you're getting a sickness certificate. You
So
don't
should
know
we say it's
what it's
sick
about.
leave? Yeah, sick leave or family or domestic violence leave?
Yeah.
Hang on, give me 2 seconds because our online attendees need the benefit of hearing this.
So we heard the question. So sick leave, this is quite separate from sick leave, and it's separate from any other leave. So it's an interesting question because, if the employee is going to be claiming leave for domestic violence issues, then how far, does the evidence have to go? As an employer, you would expect to have some validity to the request. So I would hope that the doctor would perhaps make reference to, leave required for domestic violence or domestic issues, something like that. And also something that I learnt today actually is that there is a high degree of confidentiality around this leave. So your payroll departments need to be aware that if somebody does apply for it and it's granted, you can't even put on the payroll system that it's domestic violence leave. Okay, it's got to be put down as ordinary hours or some other reference. So it's that confidential that even your own internal records can't reflect actually what the leave is, which is quite restrictive. Clearly there's got to be some tally of it because you only get a limit per year. But on the pay slip itself, so anything that the work is given to the actual employee can't have a reference to domestic violence leave on it. So.
Would it be a good idea to include it to the procedures, your HR procedures about what's specific? Would it be a good idea to add it to your people and culture procedures regarding domestic leave and what's required as evidence?
Great question by Cos.
It would be. And are you aware of the more specific, drilling down into the evidence required?
There are some evidence. Obviously, it just states that there is a requirement for the appropriate evidence. However, I can't speak to the exact type of evidence that they will accept in terms of a dispute in that matter, but definitely including the requirements for evidence in your HR policy, I would definitely, and any discussions that are had around the that this taking of this leave and discussing it in that is an option for employees to take, not hiding it away. It's a possible option out in the open. Everybody knows that they can then that there are confidential procedures through that any business that they can then take this leave. Yeah.
I think it's reasonable to have a policy that nominates a particular contact for these sort of issues that will ensure that the employees are, confident that they will be their privacy will be protected, and then a process for the particular HR department to follow once a complaint comes in, how to deal with that, how to maintain confidentiality, and what evidence you require. And I would have thought the minimum would be something from a doctor just to sign off, rather than just purely taking the worker's word for it. But I might be too harsh. I don't know.
Another question?
Just regarding that confidential, you just mentioned that we even come to put the category as family and domestic violence leave. But as I'm aware of, many payroll software, they already developed and put additional category. Yeah, put this one in. Because so that's why I ask. So is their regulations have particularly clauses that this privacy? Because first, for the payroll officer, we needed to record and calculate, because you have certain 10 days you used and the balance we needed to calculate because this is paid leave. Second, if this is confidential, what the software or whatever, you know what I mean? Yeah.
Get your steps up. Yeah, look, I don't think there's an issue with it being an internal record, because you have to obviously keep tally of it. Hopefully it won't come up very often anyway, but I think the regulation itself says it's not to be on the pay slip. So anything that could be made public or has to be, the worker might take home and an abusive partner might see, right? So as long as it's not on the pay slip itself, but if you've got it internally where it's obviously kept confidential because it's payroll information anyway, then I don't think that's a problem. So.
Excellent. All right. I will now let Mark present on his topic, which is a review of the Section 18 cases.
Thank you, Susanna. In the interests of allowing sufficient time for the next speaker to address you on permanent impairment assessments, I'm going to just cover very quickly my topic for that reason, and secondly because my speaking notes are actually part of the information folders for those who are here today, and I will send them out to, or the firm will send them out to those who aren't here today. So if I just skate over these couple of cases that I'm going to talk about, you'll understand why, and so we'll move forward. In starting the discussion today, I acknowledge that those of you who are CISA members would have potentially heard Deputy President Judge Rossi talk on Section 18 cases about 16 months ago. And he covered a number of the cases up until then, so I'm not going to go over too many or any of those other than to say two things. One is that Walmsley's case, which was the first case in this area a number of years ago, Deputy President Judge Hannon set out a roadmap, and it's a very good and it's still a valid roadmap about the sort of things you've got to understand when you're dealing with Section 18 applications for suitable employment, as to the process, so to speak, but secondly, as to all of the issues that you need to consider to properly address Section 18 when a worker makes an application to effectively be provided with employment, let back into the workplace after an injury in a way, someone who might come back and darken your door having left previously, someone who's not actually overly happy with the type of employment you're providing and wants to be provided with something else, any number of situations where Section 18 applies. So if nothing else, if you've got any risks in relation to Section 18 or want to get a better understanding of the provision, read Walmsley's case. It's a well set out decision. Just on the last couple of cases, Deputy President Judge Rossi did talk about at CISA recently. He mentioned the case of Coleman Sleep. There's an associated case of Roberts as well. They're the cases that deal with the question of whether a worker who might have had an incapacity for work in the past can exercise their rights under Section 18 at a later time when actually they might be fit again for their normal duties. And the cases have decided that a worker in that respect, if they've got no incapacity by the time they come before the tribunal in these cases, doesn't invoke the jurisdiction of the tribunal. Now, we understood Coleman Sleep was going on appeal. I haven't heard anything since. It's been some time since that case was decided. So I think we're reasonably confident that the status quo is as those cases talk about. With that background, very briefly, we're going to talk about three cases. Gaia, the reasonable practicality of providing work and what's surrounding that. Morphett, Section 18, and whether a casual or short-term contract employee loses the right to agitate for suitable employment after the time in which their contract ends. And Reimer's case, which I've described as a can of worms, for reasons when you read the case and understand some of the unique aspects behind it, and the judge involved won't be a surprise. Gaia's case, and you'll find a thread running through a lot of these cases. They do involve largely government employees. Seems to be an issue with government and suitable employment and the provision of it or non-provision of it. Ms Gaia worked as a personal care attendant in the Public Health Service. She had a number of injuries over the years. She had tried and explored various avenues to get back to some form of productive employment. She'd done a little bit of lifestyle and leisure coordination work. She'd done a little bit of admin work, largely of a receptionist type nature. Hadn't really made much of a fist of it at anywhere along the line. Never really got to the point where she was overly productive in any of the roles that she was performing. Had tried to be retrained, but really wasn't able to perform much of the role identified in that regard without effectively being handheld. So it was quite difficult to provide her with employment. She worked within a big department of Health and Wellbeing, but within a small unit of that department, and she lived in the country, so there was obviously less health units, as we might call them, where she could travel to and work, even if she was capable of working. So against that factual background, Deputy President Gilchrist talked about how far the employer had to go in this case to satisfy the obligation that it was not, from their perspective, that it was not reasonably practicable to provide the worker with suitable employment. And he talked about it being an evaluative judgment that takes into account a range of factors. What's the extent of the worker's incapacity for work? Do they require reconditioning or retraining? If retraining's required, is that on-the-job training or is it off-site training? How much is it going to involve in time and cost? Has the worker really established that they're ready, willing and able to undertake the further training they might be talking about when putting up their hand to be suitably employed? What's the size of the employer? What are the implications for the employer in bringing this person back into a workplace where he or she might effectively have to have their hand held, where they're not able to perform most of the duties of a role and everyone else has got to cover for them? It's an interesting case from the perspective that the union actually got involved in a way prior to all this happening on behalf of the other employees who are arcing up and saying, look, we're carrying this lady. So all of these factors went around in the background. Deputy President Judge Gilchrist said ultimately you've got on the one hand very small employers and on the other hand very big employers, and you might think that even big employers have to provide suitable employment in almost any case because simply they can, they're large enough. But he said in this case that wasn't going to be what he was going to order because effectively, as I talked about, this being a small health unit, remote location, he didn't expect them to have the capability to effectively provide suitable employment. Morfett's case was an interesting one from the perspective in two ways. First of all, it was a case of an injured worker who was actually seeking extended benefits, and he was a government employee, or ex-government employers, we'll discuss in a minute, seeking extended benefits under his enterprise agreement because he'd fallen outside of the entitlement period under the Act. So if those in government will be well familiar with this, and the need for him to have been notionally employed in some form of dangerous employment. Well, he used to walk around with a chainsaw, so that was a fairly straightforward one, you might have thought, but it was a contested part of the case. Secondly, and more particularly, and this leads to what I think might be an expanded scope of the provision, the fellow concerned had a number of jobs over the years with the department concerned, and at the time of his injury he was on a short-term, effectively seasonal contract. Had an injury, contract ends. He's not in employment ongoing in that regard. And one of the things that the department argued in the case was, well, Section 18 doesn't apply anymore. And the judge said, what do you, I can just imagine what this judge said, what do you mean by that? With an eyebrow raised, etc. Wouldn't that lead to somewhat capricious results? Rhetorical question, answered by the judge, of course it would. So he effectively said, it doesn't matter what the nature of your employment is, the contracts, short-term, permanent, part-time, etc. In any circumstance where you've been injured and have an ongoing incapacity for work, and putting aside the Section 18 defences employers have, access to Section 18 is not time limited just because your job's expired. And in this case, he also took note of the fact that the job the worker was in a sense agitating about wasn't then available, but again, it was a seasonal thing. Or that the fellow had performed what was other roles he identified as seeking suitable employment, whether he had performed them for any particular period of time. The judge just said, look, in the scheme of things, this bloke can do stuff. You're a big department, you've got to provide him with work. But he made some comments, and when you read my paper, you'll see, and it goes back to a case called Long Years, which was an old Supreme Court case under an old Act that talked about,
Sorry to interrupt, Mark. We've got a lot of comments coming through about background noise. It's apparently the online participants. Can I please just ask all our online attendees to place your screens on mute so that other attendees can hear Mark's presentation. Thank you.
Okay, thanks. Wasn't aware of that myself, but that's because of my noise-induced hearing loss. Another topic for another day. He talked about Long Year's case, and Long Year's case was a Supreme Court decision that basically said, in the given circumstance, an employer might have to, in complying with the old suitable employment provisions of that legislation, effectively create a new role for a worker. This has been picked up by Judge Liskey in this case, Magistrate Liskey in this case, and Judge Rossi in the next case I'm going to talk about. And Judge Liskey went on to basically open the door to say, in certain circumstances, it might be that someone on a short-term contract agitating for suitable employment might be able to push for an ongoing role and creating a whole new type of employment. So that's very much watch this space, because at the moment, Return to Work SA and the government are under pressure from the unions to revamp Section 18 and to make it more of what they see as a toothless tiger. But if you've got Deputy President Magistrate Liskey making these sort of comments here, I do wonder where the fear is of how narrow Section 18 might be, when this case probably stands as something quite different. So it's worth having a look at his comments in that case. And finally, just quickly, Reimer's case. If you've been reading tribunal decisions for about the last 18 months, Ms Reimer's features about 4 times in various ways, shapes and forms. This case was about her request to be provided with suitable employment. Now, Ms Reimer's, for those of you who might not be familiar with the case, was a school support officer, I think from memory, who developed a laryngeal problem because when she came into contact and breathed in airborne substances of a certain nature, it caused her various physical problems. You can imagine that being a bit difficult because she worked in a school. So there's hundreds of people she could come into contact every day, spraying everything from perfume to deodorant to stuff in classrooms, antiseptic sprays, you name it. she was seeking suitable employment. Based on a medical certificate from her medical practitioner, it was, in a sense, at face value, very restrictive, because it talked about she could only work at a primary school, only deal with 1 to 5 students at a time, work in a separate room. Sorry, I'm clicking through to get the slides up to date. Staff and students should be advised not to wear perfumes or strong-smelling cosmetics or hairspray. I don't need to worry about the latter. Non-antiseptic wipes or hand sanitizer to be used in that room, etc. So there were quite a few restrictions. The department concerned refused to provide the employment that was identified, put forward quite a number of arguments, and when you look at my paper you'll see what a number of them were, but the thrust of what I think Deputy President Rossi ultimately found was that, and this is my take on it, not necessarily his words, that the department might be seen to have undertaken a knee-jerk reaction to all this. It's just all too hard, and we're going to not give the person the suitable employment they identify, and they set out their reasons, including all these things that they thought were impractical. But then they presented only one witness to effectively try and give evidence about all the things that Judge Hannon said in Walmsley were part of the roadmap. So they effectively, being a little critical here, pushed out an employee from the school to answer all these questions about the makeup of classrooms, the exposure to substances, to the extent that they did, the financial impost on the school to have to make all these arrangements, the nature of the duties that were to be performed by the person concerned. And it gives rise to what I think is a very big lesson about all this, and it's part of my closing comments about doing your homework. But in the end, Judge Rossi also talked about Longyear's case again, and effectively this obligation to provide employment that might be a range of positions, not just a position. I do hasten to add, though, that at the end of the day, I think the cases will still say that in that regard, they've got to be real positions, not just made up, but beware if you leave someone as a large employer in a workplace for far too long and a range of made-up duties, it starts looking like a job. So beware of that. But short of that, and coming to a sort of wrap-up about these last 3 cases, and Coleman Sleep just before that, the cases are all about incapacity and whether there is one at the time suitable duties are being sought and decided upon at trial. It's about the availability of the duties and not necessarily the job at the time. Oh, and just on one particular aspect of Morford's case, Judge Lischke also seemed to suggest that whereas a prior case had talked about a worker not getting a leg up through Section 18 and suitable employment, where the job they identify would otherwise be the subject of a contested employment process, job application, go to a panel, get decided whether you can have the job or not. He seemed to think that wasn't as important as the fundamental expectation that workers might have to be provided with suitable employment when they're injured. So in effect, the Return to Work Act might trump the Public Sector Act, Management Act, etc. So something, again, to be mindful of if particularly you're in government. Going back to it, the summary, it's about the duties the workers being expected to perform, their ability to perform them, the history of their ability to perform them, their adaptability and training and skills that they might or might not bring to the position. It's about, in cases still, whether there's a work health and safety element. Is this person reasonably at risk of further injury in the role identified, and others in the workplace? And in the case of Ms Geyer, the risk to clients of the department, or it might be residents in a nursing home. The risk factor is still one that's relevant. The financial impact on employers is still an important one, but I suppose in a sense the larger the employer, the less so. It's about the sustainability of the role ongoing, and it's potentially the ability or the requirement to create a new position that gives a fundamentally different outcome to the nature of the first employment relationship that gave rise to the work injury. So in other words, casual potentially becoming permanent. Is that going to be something moving forward we're going to have to deal with a lot more? I've said as a sort of closing comment in the paper, size does matter in a sense if you're an employer. and therefore it's really important as a larger employer to do your homework before you get before a judge in a Section 18 dispute. So in effect, when a worker makes an application for suitable employment, you've got a month to respond. Worker can't bring an application to force it into the tribunal within that month. That's your month to get, unless you've already done it because you know what you've done previously, you've withdrawn duties and you know what's coming. But if you see a Section 18 application coming forward, or a request in the first place, you've got a month to do your homework. So all the things that Deputy President Hannon talks about in Walmsley's case that are important in trying to establish whether you have to provide suitable employment or not, go back to them. Kick around what your facts and evidence and circumstances are in your workplace. Use that roadmap as a guide to whether you think you might ultimately be at serious risk of getting an adverse order by a Deputy President where you decide you're not going to provide suitable employment and a judge tells you at the end of a hearing, sorry, but you're going to have to. So history has shown in the cases overall, those employers who have done their homework, and I call it that, have been a lot more successful than where the barriers have been put up and you're trying to fill the gaps in afterwards. And of course, with none of these cases literally have involved very small employers. It's not an issue they need to face. Now, from my perspective, that's a political issue for somewhere else. But in terms of the day-to-day management of Section 18 cases, yes, it's largely about the larger employer and how they manage these claims and issues. With that, I'll just take any questions.
Any questions? No? I am having to comment on one thing, and that is that I'm kind of coming across a lot of Section 18 sort of issues, I guess, in a lot of our matters lately. Even just today, we were dealing with a matter where we had a worker who resigned whilst he had capacity for work. And then over a year and a half later, he decides that he wants to put in a claim for further period of incapacity. The claims agent rejected his claim, and now his solicitors are trying to restore breach of mutuality, but they're also arguing that there was never a breach of mutuality, and we think we need to be pushing back on those type of matters as well. So it's becoming a bit more increasingly important, I think, to really take into consideration these Section 18 issues and get some advice on that so that you're on top of it in time.
Well, that takes you to the point where it's important to understand as a registered employer, you might have a defence to a Section 18 claim or application because the worker did in fact resign after they were injured, and there's a clear provision of the Act in that regard, but it might not necessarily stop a claims agent from acknowledging and accepting a revival of the obligation of mutuality, because in terms of that, it's a mutuality obligation to the scheme and not the employer per se, compared to a self-insurer where a breach of obligation of mutuality is a breach against them, and if it's a resignation, it's a defence to Section 18 as well. So different scenarios apply. Otherwise, thank you, and I'll hand you back to Susanna for a minute.
Thank you very much. Thank you, Mark. Should be using two microphones. I apologise. All right, a change of pace for today. Like I mentioned earlier on, although I think my surprise is somewhat ruined, but that's okay. We do have a very special guest speaker for you today. She is one impressive lady, so you know that she's a female, obviously, who prior to joining Lawson Risk in mid-2021, she spent over 10 years at EML, working her way up to technical specialist. And prior to that, she was also our work cover before it became Return to Work SA. She, of course, is now a senior claims consultant at Lawson's being SA's leading provider of injury management and work health safety solutions to self-insurers. To add to her already very impressive resume and years of experience, something that you may not have known about her is that after the AMA 5 guidelines and IAGs were introduced, she undertook the same training and the same competency tests that are required of accredited assessors. which enables her to actually review PIA reports. So, you know, before she determines whether they're in court or not, she knows what she needs to look out for. We've asked her to give us a bit of an overview of this today, as it is becoming increasingly more important and relevant in light of the more recent changes to the to the Return to Work Act, as mentioned by Tracy earlier on in our seminar. So I will get her to run you through some of the main key points, but I will say that one of those key points is that from the time that you get a claim form lodged by an applicant, you should already be thinking about what the likely WPI could end up being. So, please give a warm welcome to no other than Sue Ellis.
Thank you for that lovely introduction. Can I borrow the clicker? Oh, clearly blind as a bat. I try not to take too much of your time. How does this work? Okay. So I'm going to cover some things that I have found certainly that are really important discussions with the clients I work with, self-insured clients, and that is your impact on liability is no longer just the 104 weeks. It's actually the lump sum, not necessarily the 58, but certainly the 56 payment. And I'll give you an example. A 30-year-old who's got a 15% impairment, working full-time, can be entitled to $90,000 just for a Section 56 payment, okay? You add the 58 to that and it's above the 100,000. Admittedly, as you get older, like I am, it goes down a bit, but even someone of my age, that's $59,000, all right? Now, that is an impact on a self-insurer's liability. Actuaries will also consider that when they're doing your estimates and your annual reviews. And so if you haven't actually paid them, it's going to be factored in by your actuary. So one of the things I would say to you is don't hold off getting impairment assessments. Always ask the worker if they want to proceed, and if they do, go for it. Because I have seen a lot of workers who haven't had their assessment and you're stuck with an increased impairment because of arthritic, age degeneration, and there's not enough information for an assessor to deduct. So that's the first piece of advice I'd give you. The second is although their thresholds have changed, I don't know if any of you have got seriously injured interim workers. Have any of you got them? If they were injured, if they were determined to be seriously injured on an interim basis before the 1st of January this year, their threshold is 30% until the 1st of January 2024, okay? So one of the things that you might see is them increasing that they want to actually get their impairment done quickly or before the 1st of January, simply because it means the threshold is a lot lower for them to remain seriously injured, okay? As Susanna said, obtaining information at the claim is really important, particularly for things like knees, hips and ankles. You are allowed to deduct for any pre-existing arthritic condition for those joints, if you like, but you need weight-bearing x-rays. Getting a weight-bearing x-ray 12 weeks later, no assessor will deduct. They'll say it's been brought on by the injury that occurred, okay? So if you can, quite often what happens is doctors will actually refer for an MRI and they'll say, we'll get an x-ray as well. You say, yeah, no worries, terrific. Can you make it a weight-bearing x-ray? Because then what you've got is you've given the assessor something, because what they do is they look at the picture and they do a millimetre, okay? That's going to protect you in terms of some deductions that you can get for pre-existing and reduce your liability in terms of the ultimate entitlement that's being paid. Okay. Deductions for sorry, I've got to remember to talk and do a couple of things at the same time. Sorry about that. Deductions for pre-existing impairments are critical for limiting your liability. The SAIT has held that the assessor must deduct impairments, doesn't matter whether they're symptomatic or asymptomatic. So they might have had arthritis, like most of us over the age of 40 have got within our knees, but not had any issues. Too bad, so sad. If you've got that arthritic x-ray, that indicates there was a loss of cartilage, that is deductible. What I have seen with a lot of requests is that the requester is asking for deductions to be made with no objective evidence being provided. Now, the Supreme Court decision of Pachalis made it very clear there must be objective evidence. Now, that's one of the reasons why I encourage you to get the weight-bearing x-rays. The other thing for upper extremity, which is a little bit harder, who here does pre-employment exams? Ask for ranges of motion when you do them. So when you get the shoulder, you actually ask them, I want you to assess and give me the range of motions for every range of motion for a shoulder. So there's 6 planes. The elbow is 4 planes. The wrist is 4 planes. Get those measurements. That's your ability to actually say, I want you to deduct because we can see that there's a reduced range of motion. Okay? So think about pre-employment exams. If you don't have that information, don't give it to them. Assessors will not deduct if you don't give them the objective evidence. One of the things I have seen is with spines, everybody gets an X-ray, CT scan, and it says there's a disc prolapse, yada, yada, yada. That is not going to get you a deduction. The IAGs make it very clear those on their own are not going to be used for deduction purposes. So be mindful of that. It's a little harder with spines unless they've had a pre-existing impairment or they've had a previous injury that you've got clinical notes for, etc. But it's very, very difficult. You're better off with it's easier in the lower and the upper. So when we talk about deductions, I've seen a couple where they've said, can you please have a deduction for the right shoulder, and they're assessing the left shoulder? That's a natural part of the process. So an assessor has to take into account the contralateral sides, so both sides. So if you've got reduced range of motion on, say, the right, and you're being assessed the left, but this one's not injured, that should be taken off. You don't actually have to ask that question because that's a part of the assessment. But if you are going to ask for a deduction, make sure it's for the same joint and body part. Because I've seen it, doctors will not do it and they explain, well, you've given me for the right, you've asked me to assess the left. So just be mindful of that. A number of my clients have actually raised concerns around reading time. Who here has had a reading time bill for over $1,000? Do you know why you've got that?
Because of the regs. It's in the return to work gazetted fees that anything over 12 pages, I think.
Yep.
The doctor is entitled to then charge per page thereafter. So if you provide a very large bundle of hospital notes, a lot of which is completely irrelevant, they will charge you for every page. And I think I had one day for $25,000.
Yep. And the reason you do that, and I've seen this,
Negotiated it to 5.
yeah. But 2 things you need to be aware of. The doctor doesn't read all the documents, okay? And I've worked with the practice managers. They look at it, they give the doctor what they think he needs, and then they sit there and they count. And you get charged for all of what they've counted. WCCs are not required. Okay, so be careful about what you're providing. Make sure it's relevant to the assessment. If you want to give them a physio plan, that's absolutely fine. Make sure it's the latest one that has all the ranges of movements. I prefer treatment reports where I've specifically asked for questions instead of a physio plan. I don't know if you've seen any of the Return to Work SA physio plans, but they don't really have all of the information you may be wanting for that purpose. Rehab plans generally are irrelevant. The worker's back at work, they don't need it. Clinical notes, absolutely in some cases I encourage that. But what I've found is clinical notes when somebody's been going to a hospital, 400 pages and only 3 pages are relevant to the assessment. So you're paying for that. I've seen bills like you, $10,000, when in actual fact you could have probably actually kept it to say 500. So be cognizant of that because doctors do get their staff to count the pages, and that's what you get billed for. Documents required, as I said, surgery operation notes are obviously important, particularly when it comes to the lower and the upper extremity. For example, you can have a shoulder that's had some surgery, but there are additional awards that can be provided. So if somebody has a resection clavicle, that gives an additional 5%. So the operation notes need to really articulate what occurred, because there are differences between the surgical procedures. Some may actually provide an additional impairment that can be awarded, others will not. So it's really important that they get the notes, not just a report, but the operation notes. And the good thing is most doctors will actually provide you pictures as well, which are really useful for the assessor. All medical reports related to what's being assessed. If you're asking them to assess the digestive condition, endoscopy and colonoscopy, they don't care about the medical report for the spine. They don't care about the medical report for the upper extremity. It's irrelevant for the assessment, okay? That's another way to actually cut down your reading time. It also helps you because you're not drafting a report request that's 15 pages long. And a number of doctors are starting to complain about that. Imaging studies, again, related to the injury that you're getting assessed. Previous WPI reports, if there's an assessment for the same body part. I've already talked about pre-employment, but make sure it provides objective evidence. Okay, if it doesn't, don't include it. And as I said, physio reports. Tip for drafting. Sorry, I feel like I'm running through this. Anyway, we'll see how we go. Tips for drafting. Provide background of events in a sequential order. I've seen a lot of reports where it says Dr. X's IME report states, and then it gives big chunks out. Don't do it. Tell them something that's important. So, for example, the worker was offered surgery, we note, but has declined. You point that out and then refer them to the medical report that you want them to go to. They will go to it. They get really frustrated, and I've spoken to doctors about this. They get really frustrated when you're telling them and you've interpreted a report you may not have got right, okay? So I would suggest just highlight the key points that you think are relevant for the doctor, make him go and do the work, or her, sorry, apologies. Assessors like to use tables. So I recommend that when you're talking about supporting documents, you use tables like this and have either it in a chronological order, last report down, or the other way around, don't really matter. Because what they'll do is they'll go to that table and go, I'm not really interested in X, Y, and Z, but I want to see this, this, and this. Okay? They really like tables. They're really lovely, but they work really well with tables. It makes it very difficult when you just put it in paragraph form and you're not giving them too much, which I've seen. The other thing in terms of surgery, I recommend that you do the same. So instead of saying, look, on this date, and you've got the paragraph, and then on this date, you can actually just say, the worker has had multiple surgeries, please see table below, bang. And then they can see exactly what the history is, okay? What I have found is the simpler you make it for them, the better quality you will get back from them. What else have I got? Yes, sorry. The last one is just basically, I do review reports quite regularly. I do it for self-insurers, but I'm also currently doing it from the regulator. I do liaise with doctors around reports that I have issues with or I have concerns with. Don't assume that a doctor knows how to add up. A lot of the reports I get are calculation errors. So, for example, shoulder, I got one today actually I reviewed, and he said it's 9%. No, he misread the combined values chart. It was actually 12. And I've seen them over or under. So what's happening is you could be underpaying an entitlement if you don't get it reviewed. Doesn't matter whether it's me or, a medical practitioner like Andrew Says, John Bastian or whatever, that's entirely up to you. But they do make those sorts of errors. If you've got cord equina injuries or complex regional pain or anything like a brain injury, absolutely get them reviewed. Absolutely. And people think noise-induced hearing loss, it's a little bit of my bagwagon, is really innocuous and you don't need to get them reviewed. I've actually seen calculation errors. I've seen that they've used the hertz that they shouldn't be. On top of what Tracy was saying, although it's not in the IEGs, the Strawbridge decision made it very, very clear that it's 2,000 to 4,000 hertz that should be used. There are a couple of assessors out there, I won't name them, but they don't make any deduction for non-compensable hearing loss that may be due to diabetes, chemo, heart, or other medications. So you might be wearing that if you don't know that's what they've done. And you can see from a report, say from another person who says there are some non-compensable conditions and they've just glossed right over it. So it doesn't matter what the report is, anything that gives an entitlement, my view is get it reviewed, because it's your money at the end of the day and you don't want that liability for somebody else. That's all. Thank you. That was really quick. I'm really sorry. I was mindful of the time.
Thank you, Sue. I will invite some questions. Unfortunately, my phone has died, so I don't actually know whether we've got any online questions. Mark is indicating a thumbs down, so that's a no. Have we got any questions in person? If not, I have a couple of things. Oh, here we go. We've got one from Tracy. Oh, it's a comment. My apologies.
Just adding to what Sue said, not so much about noise-induced hearing loss, because, you know, that's a whole different kettle of fish. But if you've got claims for multiple injuries, some of which are accepted, some of which are rejected, you might be in dispute at the tribunal. A lot of the times those combination issues are legal issues, not necessarily medical issues. I think it is better not to ask the doctor to do the combination. We as in, that's the royal we, you know, the lawyers involved can work that out depending upon what claims, what body parts are going to be accepted and what body parts are going to be combined, and whether Summerfield applies or whether it doesn't apply. So there's a whole range of issues in terms of that, particularly when, I'm sure you've all seen it, you've got, you know, the gastro and, you know, the upper and lower digestive, you've got the dental, you've got the lower back, you've got some other injury that occurred at some other date, and you're being asked to send off to possibly a lead and a couple of other assessors, and somebody has to determine it at the end of the day. So those are actually legal issues, and I think it's much better when you've got those like large wish lists, if I call them that you're getting a lot of these days, to not ask the doctor to do the combination. That's ultimately something that you might negotiate outside of the medical sphere, and just get the actual assessments, whether they're compliant or not, and then deal with that later rather than asking the doctor to do it.
I can say doctors are really familiar with that. I saw a report yesterday that had 14 tables in for exactly that reason.
Yeah, there's some real doozies out there, particularly if you're in dispute with certain lawyers who are using only certain doctors, and I'm sure you all know who I'm talking about. So leave the combination issues to hopefully the lawyers and the tribunal to sort it out, and doesn't necessarily have to be something the doctor does. So that's just a comment I wanted to make.
I've got comments and questions. So one of the things that I want to, I guess, talk about is going back to the issue of asking for a range of movements. One of the frustrating things that I've come across really recently is we've had a very complex matter that's been dragging on for quite some time. And, you know, it's a matter where this particular worker is, you know, on the verge of achieving seriously injured worker status. And we've got overwhelming evidence from the GP notes, etc., talking about the ranges of movement that she had prior to her alleged work injuries, etc. And then the accredited assessor says, nah, I'm not going to rely on it. It's not reliable because the way that the ranges of movement have been measured, it's not in accordance with what the accredited assessor is required to do. So then they've said, we're not going to make a deduction. What can you say in response to that?
I'd actually either push back or not determine it and say we're not determining on the basis we don't believe that the report is, we believe the report is flawed, and you run it that way.
So given that we're in dispute, would you strongly recommend that
An
in such
IMA.
circumstances we go to an IMA?
Absolutely.
Thank you. Another thing, going back to noise-induced hearing loss and the WPI issues there, we've also had matters where only one side of one ear is compensable in terms of the noise-induced hearing loss, and we've got a PIA report, and there's tinnitus loading. But then later on, it comes to light that the tinnitus is for the non-compensable ear, and so therefore it should have not been included in the WPI assessment. So you've really got to
Some of that's around the quality of the request that you make. What I find is that if you're not clear and you don't point those things out to the assessor, so I'd say we know the worker's actually got some issues with the alternate ear. We only require an assessment for this. Any tinnitus or any other related to that should not be provided. And that's one of the issues I mentioned around the non-compensable. There are a couple of assessors out there who just completely disregard it.
And this one particular matter, we've had this issue, but it didn't come to light that the tinnitus issue was for the non-compensable ear.
Sometimes that happens.
Until after we've been kicking and screaming over the reliance of the PA report, and then we came across the questionnaire that was provided by the workers solicitor and should have been provided from the get-go, but it's a questionnaire that, that particular firm gets their workers to complete, and then they don't disclose that tinnitus questionnaire to us until we ask for it later on. So in terms of, gathering your information, make sure that you do it ASAP. When we do our...
You can ask for it, and I've had some. Actually, it's like asking for a medical authority. Sometimes they'll give it to you, sometimes they won't. If they know that it's probably not going to work in their favour, they'll say, no, we don't think that's relevant. That's a legal issue. But I've been at the tribunal where the worker actually said, oh, yeah, I had surgery on my ear and we were literally on the doorstep of the trial. You didn't tell anybody, didn't even tell the worker's rep. So sometimes that will happen. It depends on who the legal rep is, and there are a number of factors going on. But all I can say to you is if you get your draft report request right, you're probably going to be in a better position in terms of limiting your liability. If you have any questions or any support you need, I've got templates. I'm happy to review drafts. I'm happy to do them for you. I've done that for a number of our clients. If that is something you want, though, I need the whole file. You can't just give me bits and pieces, because then you get a good picture. I can sit with you, work through that draft report request so you've got a template that you can use in future. I can review your reports. I can come out and deliver training. I don't know if you're interested in body systems, but I can actually tell you how a spine, upper and a lower extremity is assessed. If that's something that you want to try and understand, it's entirely up to you. Anything WPI related, I'm here to provide help if that's something you're interested in.
Absolutely. And then the only other two things that I thought we should just briefly touch on is going back to the volume of documents that gets provided to the assessors. Obviously agree with all of your points, but just wanted to clarify two things. Well, one thing in particular, sometimes x-rays, for example, say the worker has a neck injury, but you've got x-rays for his right shoulder or her right shoulder. Sometimes there are incidental findings though, so I guess those type of scans don't necessarily need to be ignored.
Not necessarily. I mean, I always find there are issues when it comes to cervical, spine and shoulder injuries. You end up with a situation where you can have a neck described and a diagnosis for a neck where in actual fact it's a shoulder problem and vice versa. That's where it's about making sure you're on top of the claim from start all the way through so you can get that clarity, because you need to be very clear about what's the diagnosis and what are you getting assessed, and making sure that who you send it to. The other thing is you need to be really clear about who's doing the assessment. I have seen assessors, ENTs, asked to do the central nervous system. I don't know why, but that's what's happened. So you need to be really careful about who you ask. I saw one today, shoulder, worker fell, had quite a serious injury, had a head injury. The lead assessor was asked to do the shoulders and the knees, but he was also asked to do the head injury and the facial scarring. That assessor was not accredited to do so. So what happened was he got all this reading material related to everything. The client's going to be billed for that. He can't do the assessment. What it also does is it makes the worker get frustrated because they've got to go for another one. If you are going to use a lead assessor, make that the last appointment, because what you do is you get the first reports reviewed, we're good to go, it goes to the lead assessor, and then they do their bit. If you do it the other way around, and I've seen a couple, sometimes it can take 4 months for the lead assessor to get their report because you've got all the other appointments going. So just a tip.
That's an interesting point, because we do have cases where, sometimes people want to, look at a global resolution at the tribunal, and they want to have the first appointment with the lead assessor in the hopes that after that perhaps we could engage
That will
in
delay
something.
things.
Yeah.
That
okay.
will delay things.
And
those problems are also an issue in terms of the appointments, because again, and it's more when you're in dispute because you're dealing with workers' lawyers rather than workers them direct, is that they're nominating literally a handful of doctors on whatever the body part is, whether it's the gastro, the dental, or the main body parts. They're nominating the same doctors every time. So you're not getting appointments with Professor David on a mastication and deglutition, which is your dental injury, until July.
Yep.
And they want, Dr. Siapto booked in as soon as he's available. So, we to a large extent, it's kind of hard to, if you waited to do Professor David first, you're not getting anything done until at least the end of the year. And workers are kicking and screaming, saying, I want my assessments done so you can, negotiate a resolution. So it is a real problem with the limited number of doctors that are actually nominated, or in the, with the body parts that have limited number of accredited assessors. So, I understand the theory, Sue, but it's in practice, it's way more complex.
I find it's more complex when there's a dispute, and
absolutely.
it's really, really hard in terms of the endocrine system. There's only one doctor, okay? Eyes, there's only two. What I'm also aware of, President Dolphin has taken a crack at that as well in relation to a recent decision. He's really miffed because he couldn't get a urologist until November. I'm just pointing it out there. If you're not in dispute and you can do that and negotiate that with your worker, try it, and that'll make your life a bit easier.
all right, time to wrap it up. So a massive thank you to Sue Ellis. That was super, super useful. I think I'm going to have to give the mic to Mark to wrap things up for today.
Thank you, Susanna, for hosting. Thank you, Sue, for coming along and giving us your wisdom. Thank you for those who are attending in person and fighting off the heat.
Standing in front of the microphone, I'll get rid of the handheld one now. And thank you for those who stayed online. As I mentioned, my paper will come out by way of email to everyone else. Encourage those here present to have at least one drink before they leave, because it's hot outside. We don't want any dehydration. So please stay around and converse with us all. Otherwise, thank you for your attendance, and we'll be back later in the year. Thank you to the presenters for their time, and yes, have a good evening, everyone. Thank you.